Right, is everyone ready? Okay, great. Welcome to this webinar on remote hearings. In the next 30 minutes or so, we hope to answer your questions that you sent in about remote hearings. So thanks for sending those in to us. I'm Olivia Dobbie, and I'm joined by my colleagues Daniel Dyal, Tom Brown, and Caroline Musgrave. We're all barristers at Cloisters Chambers, and between us we have almost 60 years experience of litigation, most recently using video technology. So let's get started. Danny, I'm coming to you first. And the first query we've got is about the preparation of electronic bundles. So the presidential guidance has set out various requirements, and I understand that quite a few people are having issues with those requirements. The first of which is optical character recognition. Can you help us with that?
Yeah, sure. Okay, so what I'm going to do is share my screen and just give you a quick demo of how to do it. I use Adobe Acrobat. Obviously there are other programs, but I'm going to show you in Adobe, which is one of the most popular ones. I'm afraid it will be slightly different in other bits of software. So hopefully you can see my screen. Have I shared my screen with you successfully, Olivia?
Yeah, it's looking good.
Yeah. Okay, so what I've got here is just a couple of pages of the original edition of the Employment Rights Act. And at the moment, although you can see words on the page, it just comes up as an image. That's all it is. It's a picture of a page of writing. So you couldn't search that. All you need to do the optical character recognition and comply with the presidential guidance is go here to scan an OCR, click that, and it will show you recognize text. So you go to recognize text, you want to do it in this file, and you could select a page range. We'll just do it all, recognize text, and it will take a few seconds per page to convert what is currently an image into recognizable text. And so that's done. And now this has become searchable text. So you could cut and paste that, or you could just search in it like this. So we'll find the word most, and it just comes up. And Barry Clark will be happy that you've complied with his presidential guidance in that regard. So that's OCR, very simple. The only thing I would add is that it takes about 3 or 4 seconds or so per page. So if you've got a big bundle, it will take quite a while. It could even take a couple of hours for a really big bundle. So it's something to put on and go away and do something else. And you can't use Adobe to do anything else while it's going through the OCR. So it might be something to do overnight or just during a lunch break, or as the case may be.
That's great. Thanks, Danny. The next issue we've got is related to that issue, which is how to ensure that the page numbering in the index of the electronic bundle corresponds correctly with the digital number on the bundle itself, the e-bundle. I don't know if that's something you've dealt with that you can help us with too.
Yeah, okay, so I think this query, I saw this query. So I think what it is that what you want is for the electronic pagination of the PDF file up here where my cursor is to correspond with the pagination of the bundle. And very often what happens is the first document of the bundle will be page 1, but it won't be the first page of the electronic file, because the first page of the electronic file will be the index. So if you put 1 in here, you're just going to get the index. And actually, the first document in the bundle is, in this case, page 15, because it's a 15-page bundle. Sorry, it's a 15-page index. And that means that if you want to get to page 1 of the bundle, you can't just put page 1 in here. You have to scroll down to it, which is time-consuming. So there's a couple of important workarounds for this. And all you need to do is go to Organize Pages. And what you're going to be doing is renaming the page numbers on the electronic file. So I'm going to show you how to do that. So highlight all of the pages in the index in this case, because they're the ones that we're going to change. So you've got them highlighted. Then right-click on your mouse, and that will bring up this menu. Go to Page Labels. And then we just need to call the index something else, because we don't want the first page of the index to be page 1 of the bundle. We want the first document to be page 1. So we just select Roman numerals, for example, or you could do ABC, and rename it that, and click OK. And now the index is in Roman numerals. And if I just close that and type in 1 here, as in page 1 of the bundle, it's going to take us to the first page of the first document, which I have made just so it's something neutral that we can show everyone, the Employment Rights Act. So it's actually the 15th page of the electronic file, but it's the first printed page of the bundle. So you say go to page 1 and you can just put in 1. Yeah.
Excellent.
Danny, can I check if for example, after the bundle's been agreed, you have a new page, which is say page 12A, can you do the same thing with the page renaming?
You definitely can. Thanks, Tom. That's a good point. So what you would do to do that, and this is a really important tip, because obviously documents are constantly being added to bundles that have already been made and maybe shared with the other side, and the council might have already started preparing it, or solicitors started working on the existing pagination, but use that numbering in witness statements, and you want to add a document in. You can do that. So again, what you do is you go to this Organise Pages tab, and then what you do is you go to Insert. So you need to have the documents you want to add in a PDF file. So you scan them in, you save them as a PDF file, and then you just insert them. So I'm going to show you how to do that. So you go to Insert from a file, and in this case, I'm going to insert this document here, which is just my web profile for the sake of argument, and click on that, and then you just tell it where you want to insert it. So Tom, I think you said that you want this to be page 12A and following. So I'm going to tell Adobe to insert this after page 12 of the bundle, but you could do it before or after any page. In this case, it's going to be after page 12. Click OK, and it will add it in. But here's the problem. It's made it page 13 to 20 instead of 12A through to F or H or whatever it would be. And then what should be page 13 is now page 21. So we need to sort that out. How do you do that? Select the pages that you want to be 12A and following. They're already selected because I've just inserted them. And right click again, page labels. And then what you need to do is decide how you want to number these pages. So we're going to want them to be A, B, C, D, and so on. But equally, we could have made it, 12.1, 12.2, 12.3. But let's say we're going to make it 12 ABC. So select the style, ABC. Then we need a prefix, which is page 12. So we're going to put a 12 in there because we want it to be 12 for A, B, C, and so on. And then the final thing is, what's this? Start. So it says start at 1. What that means is 1 in the series of A, B, C. So if we want the first of this to be page 12A, we want to start at 1, because A is the first in that series of ABC. But if we wanted it to start at page 12B, for example, because we already had a page 12A, then we would say start at 2, and then the first one that we're creating here would be page 12B. As it is, we want this to be page 12A and following, so that's what we're going to do. We've selected the style, we've selected the prefix of 12, and we've selected start at 1, which means start at A in this case. Click OK, and this is now page 12A through to H. And what was previously page 13 is page 13 again. And so if imagine the tribunal says, somebody says, let's turn to page 12A, you just punch that in there, and there you are, we're on page 12A. So
that's great, Danny.
That.
And we've just got one final query on bundles, preparing the e-bundle before I move on to Caroline, and that is to do with bookmarking. So can you demonstrate how to bookmark, please? Yeah, sure. Okay, so bookmarking is also really important, and this is obviously something that the practice direction requires important documents to be bookmarked. So with bookmarking, you just need to open the menu bar that's on the left and select this, which is a picture of a bookmark. And then I've already done some to show you how it can look. But basically, whatever page you want to bookmark, suppose that you wanted to bookmark, for some reason, my web profile, you just go to that page and click on plus, and then just write what the bookmark is that you want. And then wherever you happen to be in the bundle, you can just click on that and it will take you to that document. So you can do that for as many documents as you want. And just a couple of other tips about that I found really, really useful is that initially when I started doing this, I had the sort of mindset that I previously had of tabbing up a hard copy bundle. So basically my tags would just be in the order that the documents appeared in the bundle. And you'd end up with a whole load of bookmarks all down here that become quite unwieldy and adjust in the order that the documents happen to appear in the bundle.
but there's no need to do that. And actually, you can be really savvy about how you make your bookmarks, and you can move them all around to wherever you want. And in order to make them more immediately searchable and manageable, you can do what I've done here, which is to put them under different headings. So I've made a master bookmark for pleadings, and then put all of the different bookmarks for the pleadings into that, although I haven't put real pleadings in here for obvious reasons. And then you can close that, so the whole thing's just much easier to follow. So to sort of have a kind of a bookmark heading for pleadings, what you do is you just make a bookmark, as I've previously shown you, and then you right click on it and you go to properties, and then you just select what you want it to look like. It would be plain as standard, but I've made it bold so that it stands out. And then that's your heading for pleadings. And then you can just put any other bookmark that you've made under that heading, just by dragging and dropping it there. And what I like to do is to put the grounds of claim separately from the ET1, because sometimes you want to go straight to that, and you can just do it in whatever order you want. So it ends up being really great. And so you can imagine that, like, for example, if there was a grievance process, you could just have a heading for first grievance, and then add under that heading of first grievance, that bookmark first grievance, all of the different stages of the grievance process, the outcome, the appeal, and so on. And you'd have them all there under one heading. So it can be an extremely efficient way. Thanks.
Thank you. Caroline, I'm coming to you next for the next set of questions. So if Danny, if you could stop sharing your screen, please. Thanks for that. One person has asked us, do all tribunals now want all bundles to be filed electronically? Is that the new normal?
That is the new normal. The practice direction makes that clear, that where one party is legally represented, the tribunal will expect the bundles to be provided in electronic format.
Great. And what do we do where we have a bundle electronically? We've got all our OCR, everything's ready to go, but the file is simply too big to be able to convey by normal email.
That's a good question, and it's a very real problem that lots of our solicitors are facing. The tribunal are essentially putting the line at 20 megabytes. If your file is over 20 megabytes, it's not going to get through the tribunal system. So think about it in advance rather than on the day of filing. There are a couple of options. There are some cumbersome options, such as breaking large PDFs in half, but hopefully a more tech-savvy solution will be to use some sort of file share option. The tribunal are open to you using Dropbox, OneDrive, Google Drive. Some tribunals may resist, but those three options are specifically mentioned in the practice direction now, or the presidential guidance. If you look at the most recent guidance from the tribunals, it mentions those options. So hopefully tribunals will become increasingly open to receiving bundles in that way. And we are told that the tribunals are creating a new secure document upload centre of their own. So hopefully that will soon become the new normal, that we can just put our files on that system regardless of size, knowing that they will get to the tribunal. But in the interim stage, exploring options such as Dropbox and OneDrive is the way forward.
Excellent. And the final question we've got is about open justice, because of course in the ordinary run of events, members of the public would be allowed to observe open tribunal hearings. So how are we ensuring that we are upholding that commitment when we're doing video hearings? What's been arranged in that regard?
Yes, and you'll have noticed that under the new rules, the new tribunal rules, Rule 44 makes this explicit, that witness statements do need to be available for inspection. They normally would be during an in-person hearing, and that rule remains the same for a remote hearing. So the question is, how do you do it? Some options are that a witness reads their statement out loud. Now, none of us want to go back to those days, wasting resources sitting listening to witnesses reading out loud. But it is one option if there are no other alternatives. Another option that's floated by the president is that the clerk could hold up the witness statement on the screen, so it could be read during a break. But hopefully a more sustainable solution will be, again, to use file sharing software. So something such as a website, which is password protected, and is time limited. So anyone who's watching that remote hearing can access that website with the usual commitments about not disseminating the witness statement, not copying it in any way or storing it, but they can look on the website, read the witness statement in the same way as they would be able to in a hearing. And it's really sensible for our solicitors to be thinking about this in advance. Do they have that software or those websites that they can use for that type of function? Because again, when parties are represented, the tribunals will be looking to them to assist with this type of technology to ensure that open justice is satisfied and anyone can see those witness statements.
And I suppose that presents problems in specific cases where you might have very sensitive issues in witness statements. I suppose in that regard, you might want to, at an earlier stage, a case management stage, want to agree between the parties what would be the most appropriate method of ensuring open justice. Because one particular party might have grave concerns that another party won't abide by any limitations that are placed on downloading and use of a document. So it might be that parties are well advised to think about that in advance and if need be, make representations at a preliminary hearing so that witness statements are, for example, either read aloud or held up by a clerk, as you suggest, as opposed to the downloadable, more permanent option.
I think that's absolutely right. And provision is made for that by the President, that there will be times when it's important to think it through and discuss it with the tribunal in advance to ensure open justice is satisfied, but also so are the principles of confidentiality over sensitive information. So that's absolutely right.
Great. Thanks. Now I'm turning to you, Tom. We've got a very specific question, but one which could actually have a broader application, which is that one of our questioners has had experience in Northern Ireland that judges have been requiring witnesses that are attending remotely to give their evidence from their solicitors' offices rather from their own home. Now, this appears to be a concern that arises from protecting the delivery of their evidence and ensuring it's controlled. So, for example, that there isn't someone coaching them behind the scenes, or that freezing of the screen isn't deliberate. Is this the experience that you've had in England and Wales? And I suppose this could go to all of us, if any of us had this experience. And what are your thoughts on this approach?
Yeah, I think it's an interesting question. My experience so far has been different cases happening in different ways. So I was involved in a case recently where the witnesses did give evidence from professional premises rather than from home. In fact, I've been involved in a couple of cases where that's happened for different reasons. I think sometimes you do want a witness to have support, which they would have if they were in a tribunal room, for example, in finding documents and in navigating around a big bundle. But I think in other cases, my experience, tribunals have been very happy for witnesses to give evidence from home. So I think it's definitely something to flag at the pre-hearing, preliminary hearing stage, to be making inquiries of your witnesses. Where are you going to feel comfortable giving evidence from? I think Caroline's going to come on to talk about some of these issues, to answer some questions to do with technical issues. Do witnesses have a stable internet connection, for example? But I think it's probably going to happen in different cases, depending on what a judge and what the parties think is appropriate.
Thanks for that. And I suppose it would also be fact specific to each witness's circumstances. So, for example, if they have to stay at home because of a health condition, then a judge should be more biddable in allowing that. Whereas those that don't, that know their evidence might be more secure if they're all present at the same solicitor's office, that might be a more appropriate way of delivering their evidence. Okay, brilliant. Then, Caroline, what are the 3 top tips for how to help witnesses prepare in advance of a hearing? And I think, as Tom says, we've got issues here with connectivity, but also matters of presentation.
Yes, I think the first tip has to be to practice. Practice. Think about your technology, practice to make sure it works. Be satisfied that your backdrop is neutral. You're not exposing any private information, pictures of your kids and so on. Have a neutral backdrop. Turn off your notifications on your computer so you're not distracted by messages coming in. Think about your lighting, think about your microphone. All these types of teething issues, which if you practice with your witnesses, you will help them feel confident using the technology. Of course, what we all want for our witnesses is that they are confidently able to give their evidence of fact. We don't want them distracted by technology, and it's a huge distraction. So if you can practice to take away any concerns they have about the technology or the using the CVP system, getting onto it in the first place, you'll help them to focus on their evidence. A couple of other top tips that I would suggest: check your witnesses have unmarked copies of the bundle and the statements. That's something that we can all physically check in a tribunal room, and we can quickly switch bundles in a tribunal room if a witness has inadvertently highlighted some paragraphs. That's so much more difficult when you're dealing with your clients remotely. So check in advance that they understand that when they give their evidence, they need a clean copy, and judges will often check that. What you don't want is a witness thrown off feeling that they've done something wrong before they even start to give their evidence. And I'm sure questions will have come in about this final issue that we may come to, and that is agree a means of accepting instructions on the day. So in advance, think about how are you going to take instructions from your client, and I suspect that we'll come back to that with some of our solicitors' questions.
Yes, I've got a couple of specific questions on that. But first, one more question about handling evidence itself during the hearing. One question is, what are the main differences between a remote hearing compared to an in-person hearing? And what should we be alive to, what those differences are and how to handle them to make sure that the hearing is most effective?
Yes, one of the key differences I found is the challenge of handling multi-screen technology. You have your bundle on one screen, you may have some questions on a piece of paper, or a witness statement on a piece of paper, you have a video on another screen, and managing this different technology is difficult. It makes it much more difficult to respond to the visual cues that we normally rely on in the tribunal room. You do need to speak more slowly, and you do need to verbalise what you would ordinarily just do physically. So, for example, if your witness is struggling looking for a page, as an advocate, you don't know that unless they tell you, whereas in the tribunal room, you would obviously see it and respond. So encouraging your witnesses to verbalise the things they are physically doing, because we don't have those verbal cues in the normal way. I would say it's sensible to err on the side of caution. If you as an advocate or your witnesses are unsure if they have been understood, then it's better to err on the side of caution and provide clarity, because again, they won't be able to respond to a judge nodding or stopping writing because they've got the point. They won't have those cues, so just be cautious in making sure that you're understood. And one final matter that is different to a remote hearing is it is very tiring to carry out CVP hearings. All of us who have been involved with them will know that it's surprisingly tiring. And we forget that in a normal courtroom, we stand up, stretch our legs, walk out the room, take a break, have a chat about something different. Whereas in our homes on a CVP hearing, it's much more intense. So it's very sensible to advise your clients to take breaks away from their screen. So we will want to communicate with our clients during the breaks, but we also need to make sure we give them proper breaks away from the screen, stretching their legs, very practical things to try to help clients with that extra level of tiredness that comes from a CVP hearing.
Yes, and you mentioned that witnesses wouldn't be able to observe the judge or wing members' non-verbal cues in the normal way. And I've also found that it works the other way round, and witnesses need to be reminded in advance that nodding or grunting and those sorts of ways they might ordinarily answer a question and it might be understood won't be as well understood through a virtual medium. So reminding witnesses in advance to use verbal answers, not just physical indications.
Yes.
Great. And finally, I'm coming back to you, Tom, and this is the issue that we touched on earlier. Obviously, during a virtual hearing, we need to ensure that we can have effective communication with our clients and perhaps with other witnesses or even witnesses once they're under oath. Can you give those watching some guidance on how we deal with those sorts of issues?
Yeah, again, I think this comes back to Caroline's point, which I absolutely agree with. It's about preparing and really thinking through eventualities in good time, not doing this on the morning of a hearing or even the day before, but really working out how you are going to structure communications. Certainly my experience has been that the default application for communication has been WhatsApp. The advantage of WhatsApp, I think, for most people is that there's a desktop application, there's a computer application, so people can type messages, and of course you can have group chats. But you might want to think about the number of chats. What kind of groups are you going to need? For example, a representative is probably not going to be wanting to receive chats from absolutely everybody, and so you might want to have a counsel and solicitor chat, and then you might want to have a solicitor and witness chat. Of course, a really, really important rule if you've got a witness chat is take the witness who is giving evidence out of the group chat so that they can't see what other people have been saying about their evidence when they're giving evidence. And that's an absolutely critical point to have a protocol in place to remove witnesses, which comes to your point about communication when witnesses are under oath. So you might then be wanting to have a separate chat with a witness who's under oath specifically for practical matters. One of the things I usually say to my witnesses is once you're under oath, you should really be thinking that communication is between you and the tribunal rather than between you and anybody else. So everything needs to happen as part of the hearing. If you're not quite sure what time, you should be coming back, ask the judge. If you need a break, ask the judge. Don't think that you can ask the representatives. But again, I think agreeing a protocol with the tribunal about communicating with witnesses is important. And then I think also, of course, in the real world, in real tribunals, during break times, it's possible for everybody to powwow. Everybody who's not giving evidence to powwow. And so I think setting up, for example, Teams meetings, Zoom meetings at the end of a day, at lunchtime, if that's going to be a more effective way for people to discuss or debrief, is an important thing to bear in mind too.
That's great. Some really practical tips there, Tom. Well, thanks very much, all of you. And thanks everyone who's watching for the questions that you sent in. Hopefully we've managed to demystify some of the most common, but also some of the more complex issues that we're all facing in coming months with respect to remote hearings. If you don't already, please follow @Cloisters Law on Twitter and LinkedIn for all our latest blogs, webinars and other useful information to help get you through the legal issues that are arising out of the pandemic and beyond. So goodbye for now.